Transparency and Campaign Finance Commission. It's now 10 o'clock. I'll call the meeting to order. The first thing that I would like to do is welcome our newest commission member here today. Daryl Hicks was recently appointed by Governor Kemp. In reading the bio that's on the website, I understand that Commissioner Hicks has got some extensive financial background, and I'm certainly looking forward to his insight from that unique perspective. You don't want right off the bat, but if you want to say anything, I'll certainly open.
Thank you, Mr. Chairman. I appreciate the opportunity, and I am Daryl Hicks, live in Fayetteville, Georgia, originally from Reynolds, Georgia. So I'm just a country boy who came to the city. I'm sure. Serve the citizens of Georgia, and this is one of the ways that I can do that. I serve on a lot of different boards, but this is working with my colleagues and learning. I'll admit up front that if I don't know the answer, I will ask questions. For the opportunity, and I look forward to working with colleagues.
I also wanted to welcome Commissioner Hicks. With a new board member, it creates change within a board, one of which we see here now, which is a shuffling of the seats. I know Commissioner Watts will be devastated to not be quite so close to me during my executive reports, where she diligently takes notes of at every meeting. It dawned on me that Commissioner Thompson serious existence on our page, so I may be hunting him down for a biography to add to the website as well. But
Looks to me from the agenda that we've got 12 items on the agenda. Before we start going through those items, Mr. Amati, is there any need to amend the agenda? Posted?
I don't believe so.
Okay. So we'll go ahead and move on to item number 2, which is election of a new commission chair. As everyone knows, Commissioner Jake Evans resigned, and he was our former chair, which has left a vacancy in the position of chair for our commission. Do I have any nominations in the form of motion from the commission for a new commission chair?
Mr.
Oh, I see what you're saying.
Which number is this?
During this meeting, but I nominate you to serve as our new board chair.
And I'll
Discussion? No discussion. I'll call the question. All in favor say aye.
Aye.
All opposed? Motion carries. Again, I want to say that it's also an honor to serve as chair of this commission. I've been on the commission now since 2016. Jake Evans and I came on just a couple months apart, so I have been here for quite a while, and I appreciate the vote of confidence from all of you gentlemen this morning, and I hope that I've. What this now does is create a vacancy in the position of vice chair for the commission, since I'm formerly in that position. So again, I'm going to go ahead and open position of vice chair.
Nominate Commissioner Eric Borden for Vice Chairman.
And I'll second.
All right, we've got a motion and a second. Is there any discussion? No discussion. I'll call the question. All in favor say aye.
Aye.
All opposed?
I'm talking directly.
Motion carries.
I have certainly enjoyed the time that I've served on the board. Colleagues, our staff, and serving the people of Georgia.
Okay. And then we're going to item number 3. Sorry, which is review and approval of the regular meeting from June the 24th of 2021. I assume that everyone has had the opportunity to review those minutes. Commissioner Hicks, since you weren't present at that, take the vote amongst the other 4, not in an effort certainly to exclude you. Okay. Again, is there any discussion with regard to the minutes as they're set forth in the package that we? I'll make a motion. Proposed by the staff.
I'll second.
We've got a motion and a second. Any discussion? All right, I'll call the question. All in favor of approving those minutes, say aye. Aye. All opposed? Motion carries. The minutes are approved. -41. Mr. Amati, are you going to be handling this?
Chairman, Mr. Cusack's going to handle this, but I did want to provide a brief explanation as to why we're addressing this at this time.
Okay.
Statutorily, the commission has the authority to consider this at the first meeting. Exercise that authority, it's considered a rejection of raising or lowering those limits. By rule, however, the commission has the ability to raise or lower limits at any given requires. But the reason for doing so now is based on inflation that we've seen, the raise. So we have 2 options. We can choose to do that next calendar year next year. My concern with waiting until next year is we'll be in the middle of an election cycle. Contributions will have been flowing hot and heavy. A number of people across donors, and I think that just creates the possibility of inadvertent violations, inadvertently over limits being given. And so I think it's more prudent to do so now before the, I guess, campaign season really gets kicking in full swing, so that everyone kind of understands what the limits are for the duration of the 2022 cycle.
And I agree that this is something that we should take up at this juncture. I think it only makes sense as we move into an election cycle as opposed to midstream. Therefore, I will make a motion that we go ahead and consider increasing motion in a second. Do we have any discussion on that at this point, just on the issue of whether to take this up as a question? Hearing no discussion, I'll go ahead and call the question. All in favor, say aye. Aye. Any opposed? Motion carries. We will now consider the increase of those maximum contribution levels. Over now to Mr. Cusack. What is
Okay, the.
all right?
WIT two, WIT.
Yeah, that's
Are tied to the Consumer Price Index as published by the Bureau of Labor Statistics of the United States. The current limits that are in place now, when they were effective, which last time the commission took this January 1st of 2019, where it set the limits on statewide candidates, the maximum they could take was $7,000 for the primary and the general, and $4,100 for any tying those to inflation, we put it into a calculator that was based on the August 2021 inflation. To the consumer price index, and that had $7,600. The inflation level was actually $7,600, 7 cents and 78 cents, which would be statewide candidate could take in the general and primary. As far as the $4,100 limit that was in place for the runoff elections for statewide candidates, that came out to there is nothing by statute that says we have to round up, but looking at the trend of inflation going statewide candidates and constitutional officers. The limits for 2019 was $2,800 for the general and primary election. With current inflation, $3,000, it was $3,043.11, which would be what that would be worth now. So we have rounded that to $3,000 would be the maximum contribution limit for the General Assembly and all other state, local, municipal candidates. For their run, $1,500 per runoff election. That has gone up to $1,600. So it's gone up to $100 there as it tied to 24 cents. So the new limits for those candidates would be $3,000 for the general and primaries elections and $1,600 for both runoff elections. The maximum.
We have any questions for Mr. Cusack? For some reason I had a feeling.
So my only question is, thank you, Mr. Chairman, is why we decided on the runoff for the statewide to go down, even though obviously 4455 is closer to the 4500.
The trend of inflation right now, it's not going to get up near that $4,500 level for a while. Argument that is closer, but the way it's
It's a
going,
good argument. It's
Very good.
argument. For consistency, instead of making a judgment call, my personal opinion, I believe, I mean, it's not a huge issue for me, but I definitely for consistency.
I agree. I guess my question is, what are you basing your analysis on inflation not getting to 4,500 anytime soon?
it's the monthly trends. So stagnant right now for the last 3 months. So looking at those trends and forecast, economic forecast, as much as you can forecast that. Fair amount of time. But as always, if we adopt some sort of consistent rule, since it's not set by statute or by rule, it's sort of a discretionary call by the commission staff.
Yeah, I mean, I would say either let's make a decision that we're gonna round, up after the 50 mark or down below the 50 mark, or we're just always rounding down or up. I mean, but for the sake of consistency, I'd like some precedence.
I tend to agree with that, and even if inflation doesn't move as fast, you don't have to increase it the next time. True.
Thank you, Mr. Chairman. At the appropriate time, I'd make a motion to change it runoff from 4,400, 4,500.
Why don't we do this, because we're gonna have to do this by motion anyway. If you wanna make the motion, why don't you make the motion to approve the new limits and just include as the new limit for the statewide runoff, the 4,500 rather than the 44? Make a motion for you.
So moved.
I'll second. Do we have a motion and we have a second. Do we have any further discussion on this?
If I may, Mr. Chairman, let me just make the record clear, let it be too clean. Increase the statewide contribution limits. Statewide candidates in the general election to 7.
We have a new renewed motion. We have a second. We have any discussion on the renewed motion?
I would request Mr. Barnum amend his motion, because he stated raising the maximum limits for the general, to include the primary as well.
So, yeah, I'll accept that amendment.
All right.
Okay. Well, then I amend my motion.
We now have a final motion with a second. Do we have any discussion? Question. All in favor say aye.
Aye.
Any opposed? All right, motion carries. I am going to go ahead and add at this point in time that I'd already mentioned that I was going to appreciate. Of course, thank you. Like we're going to go ahead and move to item number 5 on the agenda, which is the advisory opinion for consideration. It's advisory opinion number 2021-01. I believe all of the commissioners have been provided a copy of the proposed AO. I hope that it's my understanding that Mr. Cusack is also going to be.
Who sought the opinion, I don't know if he is on this. It came from a request from Mr. Matthew M. Weiss by and through real process or anything like that, but it's how or holding elective office, or a member of their staff may expend contributions pursuant to OC. But the commission has taken the question up before in advisory. in 2015, and that was actually said you can't do this. That there was just a blanket ban, and that it is not an ordinary and necessary expense for a candidate public officer to purchase a home security system as part of their official duties. Worried about some retribution from people they had sentenced to prison, something that you cannot do this, you need to said, and what are making sure that candidates do not convert campaign dollars. It's try to thread a line of recognizing that 2021 is a vastly different political landscape than 2014. Or in public office, or that you can personally purchase a Ring camera, which is common these days, a Ring doorbell, any sort of, I guess, outside regularly service out of campaign funds. Turned anything in campaign dollars into a personal asset. And what we've said and mirrored their guidance in that just renewed my home insurance, and one of the questions on there to receive a discounted rate was if I had a home security system. So if the campaign is paying for a home security system, that ultimately you should not be getting because you're then converting. Or what we've done in this advisory opinion is given the framework on which a candidate or a public officer can ultimately do this, but do this in a legal manner. That you can either rent the equipment, pay a monthly fee, but that you can't make a cap. Payroll, making campaign ads. Ultimately, once you complete your term, you complete your time in public office, then thread that needle in this case, recognizing this is a different. This question was presented about 7 years ago. That there is some need for this, but we are very cognizant that campaign dollars do not need to be turned into personal assets. And then we've tried in this opinion to give the framework on how you can properly do this.
Let me say a couple things really quick. And Mr. Weiss, I'm glad that you could be with us this morning, and we're certainly going to give you an opportunity to comment upon the AO. We did receive, I believe you submitted some written comments yesterday that I have a copy of here. But let me say, before I do that, a couple of things. First, I certainly agree that the landscape has changed since 2014 with regard to our candidates and our public officers, in Georgia. Second thing I want to say is I want to commend commission staff on the AO insofar as I think it is much more direct and to the point than some of the AOs that we have gotten in the past. This doesn't have a lot of fluff in it. It gets right to the point and answers the question. And I certainly appreciate the fact that this proposed AO does that. I understand. I just want to make sure I'm going to kind of boil this down into what I understand that the AO says, okay? Directly in line with the FEC's opinion on the topic.
It is.
All right. So essentially, what candidates have the opportunity to do now is two things. They can rent or lease the equipment, and then that rental or that lease ends at the end of the candidacy or their term in office. Just place it at their home or wherever, and leave it there throughout the term of their candidacy or their time in public office. But at the end of that period of time, they have to remove it. They have to get market value for it, whatever it may be at that point in time, and then that money goes back into the campaign.
That'd be correct.
And again, that's directly in line with what the FEC does.
Yes.
With regard to their opinion.
Yes.
I believe we have Commissioner Watts.
So, weak on what you just said, which is my understanding is that for things that don't necessarily have a monthly subscription that comes with the hardware, like SimpliSafe, I think is an example you used. You have to buy with personal funds the hardware, and then you can pay with campaign funds the rental or the subscription.
Yes, and I'm sorry if I didn't verify that you would have
Just
to,
use the word purchase. Important one to me that I'm sure Mr. Weiss is gonna get into.
yes, so you would personally purchase those, because you're making a capital improvement upon the home. So at that point, you're personally buying those, but then you can buy the system, or the subscription with campaign funds, because in the duty of, you're wanting to monitor.
So I guess my biggest question for you then is, because you used the example of the laptop loaded with nothing. You then purchase monthly subscriptions for Adobe Acrobat and things like that. So you have a personal asset that's a piece of hardware, right, that you have, that you bought with campaign funds, which you said is allowable. And then you load it with a bunch of monthly subscriptions to make it actually function. That's what you want to use it for, but you have to have the hardware to get the subscription issues to actually work. So how is that any different than a SimpliSafe? If you're going to sell the SimpliSafe for fair market value, we can get into depreciation, but if you're going to sell it for fair market value at the end of your use or your campaign, and then return that to the campaign funds, how is that any different than your laptop? SimpliSafe is a piece of hardware.
Right.
To which you then go buy monthly subscription. I'm just using your example. You then
Right.
go buy, a subscription, or you pay rent for sort of a monthly use of it,
Yes.
right? And I've had one, so I know exactly how this works.
Right.
So then,
I have a Ring camera, so,
take a laptop, right?
Mhm.
So the laptop comes built with basically Microsoft Word and a few other things.
Right.
Right? And it's just the hardware in your computer. But to really use the laptop, what you're doing is you're loading a bunch more things onto it,
Mhm.
right? That you pay generally monthly for, or yearly for, what have you. So my question, hardware, much like SimpliSafe does, that you put on your wall, and then you pay monthly for the use of it. So this is a box. I bought this as a box,
Right.
right? And the next thing I use it, I load things on to use it, and make it fun. We're trying to make between a laptop and SimpliSafe, which is nothing more than something that you can sell back, or you can sell to someone else. So when I was done renting our first home, right, I could have taken that SimpliSafe off the wall and sold it to anybody, and then they could pay the monthly subscription if they want to use it.
Right.
Or they could just use the little beeping things when you walk through the door, right? So I don't really understand the distinction we're trying to make. I would personally expand it to say that SimpliSafe idea, if you bought it with campaign funds, and then you sold it at the end of the, your campaign use for it for fair market value, I don't see the distinction. You also use locks in terms of the FEC example. The FEC said locks are okay. I don't know a single person I've ever met that takes the locks off the door and then goes and sells it when they leave. Never met somebody that's ever done that in my life. And so I think we're trying to draw too fine a line here on the distinction between hardware, right, versus
Right.
just you know, I mean, somebody has to install the fiber underneath the ground to use the AT&T, you know, security. I mean, but I don't really understand the difference.
So to distinguish between the Simply Safe and the laptop, Simply Safe laptops just helping you with campaign things. You're loading, yes, Adobe Acrobat on there, and you can pay for a monthly. But that is personal. That is a personal asset.
So I guess one more thing is the whole AO is focused on a personal asset, and I think we very rarely use the capital improvement to the home. Again, locks are a capital improvement to your home, and that was okay under the FEC's order. But if we're talking about a personal asset, there's no difference between a computer and something that you're going to mount on your wall. Anything I take home is my personal asset. I think you use a Chick-fil-A sandwich as an example, which and is your tangible object, I think you can argue is a personal asset.
Well, if you buy a laptop for campaign purposes and then you use it at home, personal asset, and thereby have converted a campaign contribution.
I guess, so in that example, you're taking SimpliSafe and you're taking it, so you're buying a SimpliSafe or any security system, and we're carving out an exception on what a personal asset or for personal use means, because we're saying that the climate has changed and candidates should be protected at their homes, right? We're not saying you can take the SimpliSafe and put it in your campaign office. We're taking this to your home, so we're carving out an exception.
Commissioner Thompson's been waiting for a while.
No, that's all right. I like where this is going.
Barb?
I didn't understand the issue to be going to the whole laptop SimpliSafe issue. This SimpliSafe or SimpliSafe, it can be removed. If something constitutes a capital improvement to the home, it cannot be paid for out of campaign funds.
Correct.
Right? So whether or not, so I think a discussion about personal assets, I don't think that.
What is considered, and this is going to be a fact-specific scenario. Character of what is being attached, it has to do with whether it's increasing the value of the home, whether it's a capital improvement to the home or not. Then you're saying it's probably not a capital improvement if you something like that. And it depends on how, say, like with the home insurance example I gave, well, are you counting that as a security system?
Right, right.
And it gets lost in the minutia of
Going
sort of
back
how
to
you-
my class, if it's removable, it's likely not a capital improvement.
Right.
It's different when you install built-in bookshelves on a third garage, right? Those are things that you can't really remove. Screwed, right? The software that goes with it canceled, the hardware removed, put in a box. I think I'm good with the opinion. I'd like to hear from Mr. Weiss because I wanted to get some clarification bottom of page 3. I saw this discussion going back and forth about personal assets, and I didn't think that was the issue. It was about whether
analysis would have to be very fact specific on what is the capital improvement on the home and the nature of what was actually purchased. So that's
Let me just read this though. Renting the security system into a personal asset, as the security company owns the home security system rather than the homeowner. In the instances of utilizing a Ring camera, Ring security camera, SimpliSafe, or any other home security device in which you purchase a monthly subscription service, the candidate or campaign would need to buy the hardware using personal funds, and the campaign or candidate could then pay for the monthly yearly subscription service using campaign funds until such time as they leave office or cease to be a candidate for public office. I mean, again, we're throwing two terms around all over this, and the AO. So if it's gonna be, if we're gonna have a conversation about capital improvement, have a conversation about that, we're gonna have a conversation about personal asset, we're gonna have a conversation about that. I think the distinction we're making on either is too fine. And I think that if we're just hardware that can be stuck on a wall and removed and sold at the end of the campaign, and I would say this is a limited exception, because I don't think we'd say the same thing for a link, okay? This is a security exception. I think we're drawing too fine a line on the SimpliSafe Ring camera versus the monthly ADT subscription.
Commissioner Thompson?
Thank you. So I wanna. Capital improvement, stuff like that, most people. Yep. The equipment, why would you deviate from something? You said the FEC said it's okay for candidates to buy security equipment, and I know that to be a fact.
Right.
With their stated that part of this advisory opinion is based on what the FEC allows.
Yeah, more persuasive of looking at sort of the trend.
Candidates to go ahead and do it and then sell it back. And I just don't understand that small line there why we don't allow them to go ahead and purchase it, understanding whether it's a personal asset or a capital improvement or whatever. And, deal with that later. Further, well, I'm not gonna go down this rabbit hole because we've had this conversation times in the past. What if somebody comes up that's not campaign related, or all of a sudden we're gonna that you're using something that wasn't campaign related but it's completely paid? If a neighbor rings you or Ring doorbell has nothing to do with the campaign, is staff gonna come in later and say that they violated the law because they rang a campaign doorbell? Do you understand? So I kind of see where the staff is going in a different direction on this one. And if we're gonna say some of it on the FEC, why aren't we going to the part saying that candidates can do it? And I also have a problem with just one. With, there are some candidates that are gonna be out there that may need to purchase it and not have the funds to purchase it instead of renting it. And I don't want to make two different classes on who has the financial capabilities personally to purchase different systems, because everybody should be protected the same. Just another thought.
My original comments, because I understood this, and maybe I don't, I certainly don't have rules as Commissioner Thompson. But it's my understanding that our AO you sell it back and that fair market value goes back into. So,
Or arguably reimburse the campaign out of their personal funds.
Correct, yes.
Yes.
That's another way of doing it as well.
Then I'm confused, because I thought specifically, the AO said that you could not purchase it.
So, and that might be something we revise, but in
Well,
terms.
what does it say now?
So,
If that's exactly where we're getting this disconnect, then that's what we need to be talking
That's
about.
the
Because
disconnect.
it was my understanding that the intent of the AO, and maybe I just, the FEC rule. And that's exactly why I led off the way that I did, about asking, is this, yep. Why do you, go ahead.
I'm going to jump in here and one, to Commissioner Watts' question of how we're using personal asset as well as capital improvement. These two terms are effectively intertwined. If an object, whatever it is, constitutes a capital, I'll get into this distinction in a second, then it has become a personal asset. Commissioner Thompson's question, and I think the ultimate issue at play here, and I think we can tweak this advisory opinion to be more clear, but on page, but I believe it's the last page. Permanent improvement that flows beyond your time in office, it's okay.
Right, so my problem here is the third to last line of the second paragraph on the first page. When you talk about simplest save, we're using personal funds. That's the line I'm drawing.
And that's-
And that's the part we can tweak.
Okay.
Soon, but the intent of the advisory opinion, I want to be clear at the very end, was
Yeah.
permanent capital improvement.
I know, I see it. And that's why I think that I understood that when I got. And then, again, I'm gonna go ahead, Weiss, again, you've been patiently waiting while we've been talking about this, and I don't know if, perhaps some of those comments that we've just addressed, address some of the comments you're gonna make as well, but, I'm gonna turn the floor over to you. I'm gonna ask her. Can someone tell me what microphone number that is?
Put the mic in front of it.
No, that actually sounds fine, thanks.
On this advisory opinion, I'll go through, just so I can set forth the DPQ, why we, as the Democratic Party of Georgia, what has been said so far. Good morning, Georgia. Thank you for giving me the opportunity. Proposed advisory opinion 2021-01. Expense is defined by OCGA 215318, for which a candidate, campaign committee, public officer, while the commission should be commended, and their staff should be commended for proposing a reverse candidates, public officers and their staff. Yep. did not allow the elected officials to install a security system in their personal residence with campaign funds. However, the DPG felt it was appropriate to ask the commission to in light of the changed political climate in the state of Georgia. Candidates and public elected officials in Georgia have faced threats of death and or physical violence at a level not previously seen. Specific instances of but it bears repeating that such threats were prevalent late 2020 and early 2021, were made against state constitutional officers, threats of physical violence in the aftermath of the 2020 election. Comments posted online, frequently of a violent or sexual nature. It is important for its candidates and elected officials who are women and persons of color. Candidate or an office holder is likely to be accompanied by threats of death or bodily harm, such that purchasing, installing, and maintaining a home security lodging equipment and all other expenditures contemplated in OCGA or their staff members lodging, elective office, for such public officers' fulfillment or retention. The FEC has issued numerous advisory opinions permitting the use Also, it should be noted that numerous states have issued similar rulings, including Michigan, Massachusetts, and California. While Advisory Opinion 2021 is consistent with the Commission's previous and the definition of ordinary and necessary expenses beyond the strict language contained in OCGA 215318, candidates and public officers. Giving the Commission broad discretion to identify expenditures on home security systems were ordinary and necessary expenses. And public officer for their staff's home. Based every day by virtue of their candidacy and or public office. And additionally, the advisory opinion is yet another barrier to participation in front of candidates, public officers, members of their campaign funds to pay the reasonable costs associated with the installation devices constituted non-structural security devices. That was the term that was used. Locks in and around a member's residence. Security systems are non-structural, and the Commission purposes because it does not enhance the value of the physical structure of the opinion 2017-07, current advisory opinion in footnote 4, by claiming that the DPG has failed to provide a threat level assessment or that the DPG has presented no evidence at the state level is really a documented statistics on all threats made to state and local officials and public officers. Widely known by members of the Commission. So
Thank you very much for your comments. I have just a few things to say in response. Number one, I have to disagree with you to some degree. Where you said that the security systems cannot amount to a capital improvement. I think that it can amount to a capital improvement. I think the FEC even thinks that it can amount to a capital improvement. As far as if it remains after your term of candidacy or your term of office, that you have to sell it for market value, and that money has to go back into the campaign fund. So,
Or in the house after you sell it.
correct. He corrects me every time that I forget about the second alternative, but yes. So I think that it can constitute capital improvement. I think the FEC recognizes that, and I think that our opinion does recognize that. And I certainly don't think that it was staff's intent in any way to try to distinguish the FEC's opinion from this opinion at all. I think that the intent was, aligned with one another. And so I don't think that footnote 4 was certainly inserted into the AO for the purpose of trying to distinguish anything. I don't read its inclusion in there. The problem that we've got right now is, and I think that it sounds like this may even fix your major point of criticism is with this, the second paragraph, where it says that, where it makes a distinction and limits it to using personal funds. Anyone propose a possible revision to that?
Thinking out loud, but I'll give it a shot. Right, what if we change page 1?
1.5.
It's the last sentence in the second paragraph. So say, we'll strike the whole thing and we'll add this. In the instances of utilizing a Ring camera, security camera, SimpliSafe, or any other home security device in which you purchase the hardware and then buy a monthly subscription service, the candidate or campaign would need to buy the hardware using campaign funds. Campaign or candidate could then pay for the monthly yearly subscription service using campaign funds until such time as they leave office or cease to be a candidate for public office. Such time, the candidate or campaign must sell home security device so purchased and its hardware for the fair market value and return such funds to the campaign. That's fine.
I want to offer, if I'm understanding the sentence as read. Say, in the instance of security system, Simply Safe, or any other home security monthly subscription service, the candidate or campaign may if you use campaign funds to do that, you need likewise with campaign funds. I mean, you got to do that.
I don't know that we need, what I'm trying to do is just, that's
fair.
option B.
Yeah,
Use your
yeah,
personal funds to do it.
then, yeah, I would draw the amendment, because I think you're right, I did misspeak. I said personal funds, I meant campaign funds.
Yeah.
But Commissioner Watts, I think you're right. The AO is intended to address a situation where you are intending to use, right, that's always an option, and we don't need to get into that.
Yeah.
Commissioner Hicks.
Sorry.
I was just
That's not
asking
even,
for,
okay. all
I was
right.
asking
So-
for
I was just
suggestions.
proposing.
The only part that I had that caused a red flag for me is you said that they must sell the equipment at the end. What if they don't want to sell it? That I sold it to myself.
Right.
Right.
So really what you're basically saying is that they have to add fair market value, whether they sell it, whether they purchase it themselves, they have to determine fair market value.
There, the candidate could reimburse the campaign or what the cost, or they sell it for whatever the fair market value is.
But I think even if they sell it for fair market value, those funds have to go to the campaign.
Right.
Yes.
So why don't we just dispense with
So
sell or
just
sell
determine
back and
fair
just
market
say,
value.
must determine fair market value and reimburse?
Yeah. And at some point, I do have a different conversation around how do you determine fair market value.
Chair?
I was making sure the microphone was still on for you. Go ahead, Mr. Weiss.
Okay, yeah, a couple of points, and I think, you know, I just want to add in, the statute does also incorporate public officers. So if someone was no longer a candidate, so they were elected to the office, or, you know, they were an office holder and then were reelected, I think under my reading of the law, they could reimburse, they would still be covered, for the use of the the fair market value would take effect when it was no longer a candidate or a. We believe that the staffs of the candidates and office holders are also incumbents, so I think that should also be.
Mr. Weiss, I'm trying to be clear on that this would apply, you know, not only during the candidacy, but during the term that the individual is in office. It would need to be reimbursed at such time as that person left office or the candidacy ended by virtue of them losing the election. You know,
The other thing is on page four, there's basically very similar parallel revisions to, it's the, it's under Georgia law.
Yeah.
And is able to comply with the guidance with their, purchasing certificate of personal funds when paying. Things that are made on page one, and also need to be made with that fair.
Because I think we could sit here all day and do this, so the sentiment is clear, I think. And I think everybody's on the same page, including Mr. Weiss and everybody in this room, so. To just amend the AO consistent with what we have discussed today and bring it up. We can probably iron out any minor details at that time. And the amendments would be page 1 and page 4 for the most part.
let me, I think this is what you're saying, but I need to make sure with Mr. Weiss, this is okay with you.
Right.
Because we've got, you know, technically under the statute or the rules, one or the other, we've technically got 60 days, you know, to respond to your AO. Again, you understand where our sentiment is coming from and what we intend for our AO to say. What I would ask at this point in time is for you to waive that 60-day requirement and give our staff the opportunity to put together a new proposed AO for our next regularly scheduled meeting, at which point in time we would then take it up again. If that's agreeable with you.
When is the next regularly scheduled meeting?
December.
Okay, all right, so,
I was gonna say, I second the,
I think we need a motion to table.
Okay, I'll make a motion to table the AO.
Before we do that, once we table, we move on. I think there needs to be some dialogue around market value, so that we don't come back here next time and have to have some discussion today around how do we determine market value for about the eBay and say that I can sell my Simply Safe for X. Or somebody else say that somebody down the street offered me X for what is that market value? What is market value and how you determine that?
Seems like this came up in another case, not too terribly long ago, about how you determine market value. And I'm not sure that we came to a definitive conclusion. We got, you know, some formula in place to be able to say what fair market value is going to be, you know, especially if somebody's factor in depreciation and everything else, you know, have a discussion, but I think that it is something that would have to be assessed on a case-by-case basis, you know, at that particular point. Just, I don't know how we could fashion some kind of black and white rule that would potentially apply, you know, 15 years down the road. And I want to have them, you know, you don't want that issue to come.
Say is we determine account. Daryl came up with fair market value, but I like the way that
And I don't know either, and I was trying to quickly find it. It's probably a security company, the security company that installed this, or that so I'm gonna go ahead and reimburse my campaign $150. This is a quote. But if you have a quote from that installed it or a similar situated company, then to me, that's a defense of, this is what I was told the fair market value was from somebody in that field. So, and that could be in a footnote, or that would be the safest way I would do it if I were a candidate and wanted to avoid any questions of impropriety.
Yes, if we really wanted to make it as fully coterminous with the FEC opinion, blocks, which security systems, so our request would be for those.
Well,
I understand if the position is that it wasn't a
with the request that was sent to us. If locks comes up at some point in time, we may have to address that. I'm not sure it's going to necessarily be the exact same.
And I personally, when we start getting into the minutia of what locks, double locks, deadbolt locks, you know, I mean, it get real granular. I appreciate the concern. I wouldn't want to try to get that granular in an AO.
Is there any further discussion before we hear, I'm not sure if we ever really got to a conclusion on that, but I guess the point is, maybe we'll look into, how the FEC defines that and how it's set forth in there.
And
Yes.
And I would just add, I mean, I wouldn't try to come up with a formula here. I don't think we're going to, I will tell you right now that the five of us will never agree on that formula. This AO will never pass. So come up with, some flexible definition to the extent we're going to actually add it here. But I will say that Commissioner Hicks, and we have pushed the staff for years now to make these AOs as clean as possible. And, the question is whether this is an ordinary expense, an ordinary necessary expense. I think perhaps, and I'm not inviting it ever, another AO request could be, how to determine fair market value. But I do, given the question, I think we can come to an agreement on this.
Yeah, look, I'm okay with that. It's just that if it ever comes before us, I'm gonna be real lenient on one definition versus another because of being objective versus subjective.
Yeah.
In our rules.
Sure.
I'm sorry, I had one more discussion point, but it's not related to the current. There's something I want to address about the AO before we move on.
Well, that's what we're doing.
Okay, all right.
There's a motion to table.
In Mr. written statement and as well as what he presented here, I read the footnote, and the footnote relates to considerations by the FEC and threats against U.S. state or U.S. House of Representatives, and what the Sergeant at Arms determined. Whether you think, or the staff thinks that there needs to be.
It can be struck. Sort of fleshing out how the FEC evaluates access to intelligence that the
Sure.
normal public doesn't. It's sort of getting context of how the FEC so it can be struck.
I would ask that it be struck.
Okay.
And I want to make sure I state why. I mean,
Barnum, the intent of the footnote was not to your opinion, as they have sort of different political climate, and that there are, you know,
And I think that that's completely fair. I also don't want this advisory opinion because it will live on.
yes.
That there was somehow a determination made by this board that, you know, there are no threats to our statewide candidates. Watch and read tells me different. And maybe make that clear as if we're gonna table this, right? I agree with Secretary Marty's point, but we also have a different political climate now. Yeah,
We've all experienced the past year,
yeah,
We-
that's right.
for better or worse.
On both sides, right?
Yeah,
We're-
We're all here in 2020, 2021.
That's right.
Yes.
So, I agree with Commissioner Barnum, by the way. I actually made comment on this before, that I didn't think that footnote 4 was actually,
Yeah.
again, down to the nitty gritty on the response and the, you know, answering the question of the AO, it's another one of those things.
Table the AO and amend it as discussed today and hear it at the next meeting.
We have a motion and a second. Do we have any discussion? Again, we thank you very much for the request, regardless of what Commissioner Watts says. And also for your written submission and your time here today. We certainly invite you, to come back to the December meeting, and hopefully we'll have an AO together at that point in time that everyone agrees on. Thank you. Back to the agenda. We're now going to item number 6. Looks like we've got 3 consent orders. Is that right?
Correct.
Handling all 3?
I'm handling all 3.
Okay. I'm going to go ahead and
That's it. That's it.
21-0009-C in the matter of, is it Eshe Collins?
I believe it's Eshe.
Eshe Collins.
Yes.
All right.
And that one, I will address that one first, and I just want to note that the 21-0010 consent order based in Estevez is quite similar facts. So I may sort of explain both of them together, just for, Collins represents District 6, Mr. Estevez represents District 9. They've both been serving since 2013. They're both currently investigating both of these. Seem to have more money, or reporting that they had more money in their campaign accounts than it would rationally seem. And in investigating and speaking to both candidates, there was some understanding between both of them that they were supposed to be pulling forward their balances for the entirety of the time that they've been serving on the board. So, for example, Mr. Estevez would report every contribution that he's ever received since 2013 on his 2020 or 2021 campaign. Makes it look like that as of the 2021 election cycle, he had $130,000 in contributions, when in fact he did not. over the course of the entire time he's been serving on the Atlanta Public School Board, sure the specific election cycle. So, and Ms. Collins was essentially doing the same thing. In investigating, I went through their bank records, I went through their reporting from 2017 to current, because 2017 was the time period in which both of the complaints were concerned. Neither of them were doing anything. Their accounting basically matched what the reports showed. There was just basically a artificial. They were incorrectly pulling forward contributions that they received for prior election cycles in the current election cycle CCDRs. Collins had a couple other accounting errors that I worked with her on. She missed some filings in 2017. They're both local candidates who aren't as familiar with all the rules as some of the statewide candidates are. And in crafting these consent orders, I was working on educating them more so than anything else. And I think the violations there were improperly filing in October 2017 CCDR, filing in December 2017 CCDR. What she ultimately should have done based on looking at her bank accounts and how she was reporting on her CCDRs is filed an affidavit of exemption, because she wasn't taking in much money during the time that she was serving. Quite frankly, wasn't taking in much money even when she was running. So she would have qualified for the affidavit of exemption, which would have allowed her to been exempt from certain filing requirements, which would have allowed her to avoid these violations. So now she assessed a civil penalty of $1,000. She willingly agreed to that. Was very easy to work with. Was very willing to learn about the requirements of reporting and to fix it going forward. Mr. Estevez was the same way, very open to learning about what the requirements were. We sort of got into the nitty-gritty of exactly what the language says in the code about pulling forward the correct amount. In the findings of fact, the second paragraph, I sort of lay it out, and I'm gonna put it on the record here so that we have it. But under that provision, which is OCGA 21534 BDI, total contributions and expenditures shall be reported for an election cycle. And the first report for that election cycle should list the cash on hand brought forward from the previous election cycle, if any, and the total contributions received during the period covered by the report. And that period covered by the report is where some of the confusion existed for both of these. Final violations for Mr. Estevez were that he improperly reported total contributions basically from 2017 to 2021. And then there were some itemization errors on his 2017 reporting that I worked with Juan to fix. He is amending everything from 2017 till now to do so before the end of the year. He's currently again, that election is in November. So I've asked him to prioritize amending his most current CCDRs to reflect what he's actually received and what his actual totals are. And the fine assessed for him was $925, and he's willingly agreed to pay that and avoid making these mistakes in the future.
One question, and I'm sure that you guys are just gonna hate this. Case on the other end of the spectrum, where
I'll use Mr. Estevez as an example just because it was a large number that he was pulling forward, but as he begins to campaign in 2021 for the November election, anybody who's going up against him would take a look at his very first CCDR in January and say, oh my gosh, he already has it's not necessarily untrue that he has received 130,000 over the course of the time that he's been in office. He has received that many. I was able to verify that with his. it might deter any candidates from going up against him if they don't think that they have the ability to raise as much money as.
Not just to call him A for this reporting period, he was actually. First case that the candidate or the incumbent should have filed, or could have filed an affidavit. Campaign, because if they filed a DOI and they've been reporting because they were gonna go over the 5,000 or 2,500, not gonna go over in the next election, they just file the exemption statement and they no longer have to file? Because I could say this, previously, staff at the commission, right or wrong, has said that they would have to terminate their campaign and then file an affidavit. But if you file DOI, you have to continue filing until you no longer have. Because here's my point, if I have $40,000 when I win my election, okay? In my next election, I have no opponent, and I file a statement of exemption under 2,500. I do not have to file anything else. Is it okay to do that? Is that the staff's opinion now?
I mean, my staff can jump in and tell me I'm wrong, but I think that's proper for that cycle,
For that election,
for that succeeding election cycle, file the
for the
affidavit.
whole election?
Yeah.
Always been that the affidavit of exemption is good for the election cycle in which it is filed. If you raise $40,000 at your original run,
Right.
and then you file either accept more than $2,500 or $5,000 depending on the reporting cycle, or spend $2,500 or $5,000. So if you just leave your $40,000 sitting there and don't do anything, you
The
No,
filing
see,
authorities never get it.
That came from the commission staff, previous commission
We'll
staff.
talk about
Well,
it.
no, I just think there needs to be some kind of clarity to the local filing authorities, because there's a lot of confusion on what their people could do. Because I take care of a lot of local people.
There's a lot of confusion by local filing authorities
There's a lot
on
of
their
confusion
own
right over
accord.
here where I sit too.
But yeah,
To provide additional clarity to sort of the conversation I had with Eshe, because she was in a position where she was missing filings while she was in office, and if she had utilized the affidavit, she wouldn't be subject to.
And the work that you've done on those cases,
Sure.
not only with regard to, the prosecution part, but the education part is very important as well. I'm going to go ahead and make a motion with regard to case number 21-0009-C in the matter of Eshe Collins, that we approve the further on the next one, do you?
On estimates.
Yeah.
They were very similar factually.
Okay. I'll go ahead and make a motion as well. Case number 21-0010-C in the matter of Jason Estep. Case number 21-0019-C in the matter of Priscilla G. Smith.
Chairman, so I believe Ms. Smith is also here. We have worked together. She willingly signed this consent order. It's fairly black and white. It's essentially a matter of sort of misfiling deadlines or incorrectly reporting reports. I'm not a huge fan of just reading these, but I wrote this in a way for maximum clarity, so I am just going to go ahead and read the first paragraph because I think it does the best job of explaining this case. So the respondent, Ms. Smith, she was a candidate for election to House District 34 in 2020. The House District seat was then vacated in 2021, so a special election to fill that seat was set for June 15th, 2021. Ms. Smith qualified to run in that special election on May 5th, 2021. She ran, and then the runoff for that. So for the runoff, for the special election and the runoff, there are different filing dates than would be for a primary. So as a candidate, she was responsible for following all of the filing dates. First, April 30th, June 30th, September 30th, October 25th, and December 31st, and are afforded a 5-day grace period in filing the required reports. And then an unsuccessful candidate is required to file for the grace period, or for the remainder of the election cycle rather, and then upon having excess contributions must file supplemental. In the event filing deadlines occur 15 days prior to the special election with a 5-day grace period, and 6 days prior to the special election runoff with a 2-day grace period. And so in this case, the violations ended up being, there was a failure to file the December 31st, 2020 CCDR, which would have been that supplemental filing after the 2020 election closed. She untimely filed her 15 days prior to the June 15th, 2021 special election. So it essentially was filed outside of the 15-day window and the 5-day grace period. She untimely filed the 6-day report that was required. And then there were contributions that should have been disclosed on that December 31st, 2020 supplemental report that were later disclosed in the 2021 report. And we appreciate that the respondent attempted to disclose those misreportings. However, for transparency purposes, it is quite confusing for other candidates or members of the public to look at her reports and see 2020 expenses and or transactions on a 2021 report a couple months later, and that's where that violation. Respondent will be paying late fees totaling $250, and then the civil penalties amount to $750.
And it is my understanding that Ms. Smith is with us today, is that right?
Yes.
Ms. Smith, is there anything that you would like to add to anything that Ms. Perlis has given us with regard to the presentation regarding the consent order?
So I have two things to say, if I may.
Okay, if you want to come up to the mic there, and Ms. Young, can you tell me what number is that right there in front of where she's going to be standing?
To commend the staff at the ethics office. Ms. Perlis, everyone I've ever had to deal with over there has been extremely helpful and very pleasant to work with, and I have a lot of respect and appreciation for that. Say that the kind of education that I needed to get as a candidate was, part of that had to do with COVID and the like I got the trainings that I knew I needed to get and thought that I was going to be able to get, but also that the fancy packages that you get from books and making sure that I wasn't doing.
And you fully agree with and you know.
Already paid the fine.
Okay. Coming to that.
Thank you. firm.
With that being said, I'll go ahead and make a motion. Case number 21-0019C in the matter of Priscilla G. Smith, that we Second, any discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
I do have a question, not about that, but about experience have been that a consent agenda once, unless you wanted to pull an item off, is a different reason why it's done this way here.
I don't know that, tell you that there is a different reason per se, why it's been done here. I can tell you that for the 5 years that I've been on the commission, that it's been done on a case-by-case basis. I don't That's what we do with our administrative dismissals, because we don't take any action. But I believe the way that has been interpreted is that
Because of action.
correct. A lot of times we do have folks that actually come and appear on their individual cases.
But it is that they've all agreed to it, and you're
Yes.
basically just approving what staff has said from that, on whether or not you will accept it, unless there are instances where you say you don't accept it, which is where you would then pull it off. I want to talk about this one specifically. I'm just asking, because I know that under normal circumstances, I was just wondering, because I do serve on a lot of these different entities, and I know that consent agendas are normally voted on as a cluster unless you wanted to take it off and vote on it.
It's just, it's one of those things that has just been done this way.
Yeah, I first started out working, I was an internal auditor, and every time they said to me, that's the way we've always done it.
It's usually. All right, that's fine. We'll definitely, look into that. I know that though historically, and again, maybe this is just in one of those cases where we would, have a commissioner want to pull it off. Get debate over some consent orders.
And I think you do pull it off. I'm not suggesting that you don't if you got a commissioner,
Right.
unless you just want to hear the staff talk about it and describe how they did it. You have the alternative. You have the option to pull it off.
Let's go ahead and move, missiles, item number 7 on the agenda.
All mine.
Oh, I tell you what, you can just zip through these one at a time again. I always took pleasure in reminding Chairman Evans that we don't take any action on this. So we will.
Some expenditures during his Senate District 27. For billboards, and how it was alleged was that he didn't disclose these specific billboards, so it'd be billboard on Canton Highway. And it just was put on there as billboards, which is what's required. So there was some, I guess, disclosed that these were for yard signs, but the person wanted it disclosed from yard signs from this store on this. Ultimately, he disclosed everything properly, so that's why this is being administratively dismissed, each disclosed by the campaign. One is in the matter of Mac Taylor. This is case number 2015-0. Third-party complaint that was filed that Mr. Taylor had to do with a private investigator's report on everybody that was in District 122 election. A private investigator, I believe there was 5 people. Accepted this information. It appears from every document that I was given, it was alleged that he had accepted it, but from every document I was given and from follow-up, he never utilized it, accepted this information, but it was offered to him. So in this case, strange case in that he basically peddled all this to everyone and nobody used it. First, who's a lobbyist, failed to register the cityhood movement in first called someone and said he was a lobbyist. He had no lobbying expenses for the listed for them, but he did. He was a lobbyist for other entities during that time. Last one is 21-0014. Of 2021. Personal financial disclosure statement in various campaign. General election cycle, and the complaint alleged that she didn't file her PFDS for this year. So she would only file if she was an incumbent because it's going back when she qualified for office within 15 days. Subsequent, yes, because she's not a public officer, so she wasn't required to file that one.
That will take us to our next item. I know Commissioner Watts, what time is?
I would suggest that we could do the executive session like at lunch. Maybe,
I thought that you had something you had to do with it. No.
well,
Body to the report of the executive secretary.
Budget. And of course, he stepped out, but I want to commend Mr. Morris, hand in hand with myself, with the House, in regards to the budget over the past 6 months for this next fiscal year. As a result of our work in it, we saw an agency budget increase of approximately 34.3. The annual budget for FY 2021 was $2.219 million. And in FY 2022, through, I think, the good work of this commission that's been recognized in our, there's Mr. Morse. I want to thank Mr. Morse for his hard work on this publicly. But as well as, explaining to the legislature what we've been doing, they agreed to increase our annual budget in FY 22 to $2,980,000. Roughly 2/3 of this budget increase is allotted for staff increases, which we have started to see the process of filling out and supplementing staff over the past few months, and I'll talk about that in a minute. The remaining roughly 1/3 to the building out of our third-party API functionality for the new e-file system that will be going online. We're in the process of building that out. We're working with our third-party vendors. I feel confident about the direction that's going. But about 1/3 of that budget increase, I don't anticipate to repeat. Knock on wood. Hopefully we'll have that all ironed out, and 1/3 of that was dedicated. There has been some nominal relative to the big budget increase in spending we've seen at the Office of State as well as an increased caseload over the last year and a half that we have provided to the Attorney General's office in, the number of cases. Looking at potentially somewhere in the range of an additional $50 per year that we hadn't typically anticipated paying. And tend to have some conversations about those rates with OSA, but we'll also talk to the legislature about making sure we're not shortchanging the commission's budget just because we have more cases that are going through to state administrative hearings. All that being said, I'm relatively happy with the 34% budget increase. That's nothing to sneeze at. As far as what we're doing with that staff-wise, brought on or have hired tentative effective dates later next month. Kiwa Julie McDowell is coming on as a business. Accounts receivable and payable process. He's a certified fraud examiner, an auditor with to our investigations, and we have brought on effective tomorrow our education division. We poached her Culture Commission, so we've got an experienced trainer and educator that we're going to be bringing on. One, note of education resigned about 3 weeks ago. And when she did, I told her congratulations and condolences because she is the new head. We're excited for her. It's a job that she has been passionate about for years. So we will be replacing our education head for that division. Finally, this year's signing die happened the afternoon before our March commission meeting. So I walked in, having been here till about 1 o'clock on legislation, and I don't know that I really fleshed out in my finest moment, sleep depriving. But HB 333 was a pretty significant ethics reform bill that we worked with Chairman Chuck Efstration in the House Judiciary. That passed the House unanimously, 162-0. It got mired in some intra-Senate politics. Near the end of session, we actually passed SB 120 by substitute in the House, sent it back to the Senate to consider on sine die without any of the drama that had been attached to our bill. SB 120 is on the table in the Senate. Morris and I have been working diligently with Senate leaders of both parties. I am cautiously optimistic we will not in session. There had been some talk about bringing this up during special session, and it wasn't until recently that the terms and limitations of the special were defined, but ultimately that's going to be limited to local legislation and redistricting. So my hope is to have SB 120 taken off the table and passed by the Senate in January of next year. All in campaign finance law, a number of issues that many members of this commission have seen crop up in cases and, unintended blind spots, maybe some things that needed to be updated from previous law. But we're excited about that. So those are the three primary things I wanted to update the board on, and I'm happy to take any questions about those. I know it's not any questions.
Do you have any questions for Mr. Amati with regard to his report? To number 9 on the agenda, Ms. Young, you have a report for the Attorney General?
Yes.
Yep.
Okay. Yes, thank you very much. We've had a active. Better?
Yes.
Okay. We've had a very active and busy couple of months in both courtrooms. In the administrative hearing, we received a summary determination. Remember that one? It's a political committee that the action committee that had exceeded campaign. Fry entered an order finding in favor of the commission on both counts. That with regard to certain aspects of their campaign, they were operating as an independent camp. Election committee, and in doing so, John Thomas were the school board people that were running that case. Harris has sought reconsideration of that order, and so some subsequent briefs have been filed. We're just waiting to reissue what. Also had a number of preliminary motions in both of the John Oxenine cases. Motions on behalf of seeking to dismiss both of those cases. Fully briefed and argued, and we are still waiting for There are two. Local action committees, 10 related acts that we can then order effect one.
Those may be consolidated though, right?
The judge has inquired about consolidating the cases. back to the Court of Appeals, which is holding the banking records. Judge Davis in Gwinnett County has entered an order that his original orders set under Rule 91160 and which would be to set aside a judgment for lack of jurisdiction in the inducement. Following our previous partially enforce the subpoena, but restricted the documents, the scope of that subpoena significantly.
John, we appreciate your report. It looks like the next item on the agenda is our executive session to discuss, matters of pending litigation. I don't think that we actually have anyone for public comment, but we could move to amend the agenda to take public, to do the first. It's correct, right, that no one actually signed up for public comment, is that right? Correct. Let's just go ahead and do that then. I'll go ahead and make a motion that we amend the agenda to go ahead and take up public comment before we go into executive session. Do I have a second?
Second.
Discussion, I'll go ahead and call the question. Under this agenda item, but again, I'm just going to go ahead and it's asked. Anyone have any public comment? Anyone here to speak? On then. I will entertain a motion to go into executive session at this point. Areas will be in executive session until such time as we come.
How much of the
Here. You're out this.
All right, we'll call the meeting back to order. We have gone into and out of executive session. I think the only thing left on the agenda is adjournment. We'll have a motion.
Second, first.
So moved. All right, we've got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
Any opposed? All right, motion adjourned. Thank you all.